Welcome back everybody to Criminal Law. In this video we're going to continue to talk about the issue of consent as it relates to sexual offences. Previously we talked about what consent actually is and how the Sexual Offences Act seeks to essentially establish the presumptions and the evidential burdens for establishing a lack of consent. We also talked about the concept of deception as a form of lacking in consent, the ability for an individual to deceive another into engaging in sexual activity. This is done through a number of different means, one of which is impersonation, and then also we talk about the relatively controversial case of Crown versus Jeter, where deception as to the activity itself was not present, but rather deception as to the consequences of the activity, meaning that a deception as to consent was not present. This video is going to talk about the mens rea of these specific sexual criminal offences, talking about the concept of belief in consent. As you should know already, because we've discovered this on our examination of the crime of rape, there does not need to be just the lack of consent on the part of the alleged victim. There has to also be a lack of reasonable belief in consent on the part of the perpetrator. So we're moving on, essentially, to examine the mens rea elements of the Sexual Offences Act from 2003, the concept of consent as conceptualized by the concept of reasonable belief. So, just like with the previous lessons, we are going to be using the crime of rape as a benchmark offence for our discussion of these considerations. We could discuss this in relation to the other sexual offences found in sections 1 to 4, but for the most part we're just going to rely on the crime of rape because of its simplicity and the fact that we can examine the concept of both consent and a lack of reasonable belief in consent in a very concise way. So, before the passage and the entering into force of the 2003 Sexual Offences Act, when we talk about the concept of consent, we had relatively difficult determinations found in the old case law. There was some back and forth in relation to what consent actually meant and what reasonable belief in consent actually looked like when we looked at particular cases. This ultimately leads to the point where authorities, i.e. previous old case law, points to the idea that it was up to the jury to almost draw the line on what the concept of consent was and the determination of what constituted a consensual act. And as a result of which, the traditional case law on this matter took the view of something of an evidential perspective. It was for the matter of the jury to deal with questions of consent. We can see this in the 1981 case here of Crown versus Olabuja, where it says the following. They say that the jury should be directed that consent or absence of it is to be given its ordinary meaning, and if need be, by way of an example, that there is a difference between consent and submission. The dividing line in such circumstances between real consent on the one hand and mere submission on the other may not be easy to draw. Where it is drawn, or where it is to be drawn in a given case, is for the jury to decide. So the question of what consent actually means in the context of sexual offences, as cited by this case, is that of the definition being given by its ordinary meaning. We take an ordinary meaning of the definition of consent as found in previous in a dictionary and in previous cases, and then we will make a determination on the basis of that ordinary meaning. The dividing line between such circumstances between real consent and mere submission, on the other hand, may not be easy to draw. What this is referring to is the fact that in some circumstances, you could have a situation where an individual consents to sexual activity, but may do so reluctantly, in the case that they may not particularly want to have sexual intercourse, but they instead submit for the purposes of whatever reason. And so, can we make a delineation between submission or reluctant acquiescence and that of real lack of consent? And this is something that this case establishes, that the jury is to decide where this distinction is. Well, from that, and from the passage of the Sexual Offences Act, we find that the concept of consent is defined in Section 74. We know this already. Section 74 says that a person consents if he agrees by choice and has the freedom and capacity to make that choice. So not only is there the ability for an individual to choose, i.e. they have a freedom of choice, but there is a capacity for them to make that choice. So they could have just as easily made the opposite choice, and it was their own free will that leads them to and causes them to consent to sexual activity. And so this refers essentially to the idea that consent is a process by which the alleged victim is given a choice and also the capacity to choose to do so. There is the capacity to make a choice as to whether or not they will or they will not consent to sexual activity. The case from 2007 of Crown versus Bree looks at this case and illustrates this point. And it also essentially gives us an interesting examination of the various different modes and methodologies of consent, and the extent to which consent can be either sexual intercourse which extends from, quote, passionate enthusiasm to reluctant or bored acquiescence. These are two sides of the spectrum in terms of consent, but the key point here is that they are still both elements of consent. You can consent to sexual activity even if you do so reluctantly or through bored acquiescence. You can consent to sexual activity in the sense that you are passionately and enthusiastically engaging in sexual activity. Both of these things can still represent consent. And its absence includes quiet submission or surrender, as well as determined physical resistance against an attacker, which might expose the victim to injury and sometimes death. This second part of the passage is talking about the various modes of the lack of consent. So whereas the presence of consent can be illustrated through either passionate enthusiasm on the one hand or reluctant/bored acquiescence on the other, the absence of consent could include a quiet submission or surrender on the one hand or physical resistance against an attacker on the other. Both of these could also represent a lack of consent.